Good afternoon, everybody, and welcome to today's webinar. It's going to be about GDPR essentials for union reps. I'm Anna from the TUC, and I'm joined today by Edward Cooper, who is a solicitor at Slater and Gordon. I'll be coming on to him in a second. Just a little bit of housekeeping before we get going properly. Just first of all, we have live captions on this webinar. There's a green button underneath the video, so please click that to watch a live transcript of the webinar. It's great to see so many of you already introducing yourselves in the chat panel. We actually have a record number of people on our webinar today. We're really pleased. So it's great that there are so many of you tuning in. And because there are so many of you, we want to find out more about you as our audience. So we've got a couple of polls that I've just made visible to you. So at the bottom of the screen, next to the Ask a Question panel, there's a little button that says polls. Please start voting in the polls and tell us a little bit about yourself there by answering our questions. If you've got any questions for Edward, please post them in the Ask a Question panel. That's a button at the bottom of the screen as well, that if you click, it will pop up and post a question there. We will do our best to answer as many of the questions as we can. We probably won't have time for all of them, but I'm hoping we can cover as many of your questions as we get chance for, really. So as I said, I'm joined by Edward Cooper from Slater and Gordon, and we've got some questions for him about GDPR. So many of you have already said in the chat panel that GDPR is a really important subject for you in your role as a rep, and you want to find out more. So that's what today's all about. So hi, Edward. Can you just introduce yourself briefly before we get going with the questions, please?
Thanks very much. I'm Edward Cooper. I'm a trade union lawyer and have been previously at Russell Jones and Walker and now at Slater and Gordon, where I head up the trade union practice there.
That's great. So we imagine that you've already had quite a lot of dealings around GDPR with trade unions. So our questions cover that, but also some general points. So first of all, GDPR, what does it regulate, and what do these laws require?
Thank you. Well, broadly speaking, GDPR is concerned with privacy rights and the use of personal data. The starting point is that you've got to anticipate that others, where you deal with their personal data, would expect you to deal with their data as you'd expect them to deal with your own. The intent of the GDPR is that the privacy issues and data protection issues are up front in how you operate, both an employer, but more importantly as a trade union, and indeed as a rep. That sounds very frightening, but it shouldn't be, because some of these principles are relatively straightforward, and I try to keep it as simple as I can today, if possible. The starting point in terms of privacy by design is people know what you're going to do with the data you hold on behalf of others. So each trade union will have, or should have, what is known as a privacy notice on their website or elsewhere, which will explain how they're going to use the personal data of others, and particularly of their members. The GDPR then regulates how that data is used, and that is described as processing, but broadly speaking, it's how it's stored, how it's held, how it's searched, how it's copied, how it's provided to others, and indeed when and how it's destroyed. And there are certain conditions which have to be complied with before the data is used. I'll come on to that later. But one of those will be a positive and unambiguous consent by a member for the personal data held on behalf of that member to be used, how it's to be used. The GDPR then applies certain principles as to how personal data is used. So it's only be used for the purpose for which it was obtained. It's accurate and maintained as accurate. It's not held for any longer than is necessary. And importantly, it's held subject to appropriate security requirements. On top of that, the person whose data you hold has certain rights of access, rights to have it erased in certain instances, rights to be the information to be rectified if it's inaccurate, and of course, as I mentioned at the outset, rights to be informed as to how you hold it and why you hold it. GDPR introduced some significant governance requirements. So each union should have a data protection officer who will have to manage the handling of data throughout the organization, including that handled by reps. And there are significant issues arising where there are breaches. In other words, if you inadvertently pass personal data of somebody to a third party in error, you must notify your data protection officer very promptly, because they will have obligations to notify, in some instances, the information commissioner within a very tight time scale. So broadly speaking, GDPR provides a framework in which personal data which you handle is to be managed and held. But of course, although we will focus to a large extent on how that data is used by unions of their members, and no doubt non-members as well, we'll come on to later, it also, of course, provides you with a sword in terms of how you deal with members' claims, personal casework, where it's not uncommon for a union or representatives to submit data subject to access requests to their employer. So it's not all one way in terms of having to manage your own position, but it can also be used as a sword in relation to how you can progress personal casework on behalf of members.
That's really useful, Edward, thank you. So we've covered the general principles of GDPR there, and specifically how a trade union might need to operate. We all know that unions operate perhaps in an unusual way. They're not quite like other organisations in that they are a central body as well, but they also have a network of reps who literally represent the union. So we'll come on to some of those more specific questions shortly. But I've got a couple of questions first about the general outlook. So as we know, the UK is no longer a member of the EU. Now, GDPR is European legislation. So now that we've left the EU, what is our position around this? And does this change anything in practice for trade union reps?
The short answer to that is no, it doesn't change anything in practice. The legislative framework has been changed so that we now have something called UK GDPR, which effectively is the old GDPR with some changes which relate more about cross-border transfers, which I don't think are the things which are going to impact on most trade union reps. So to all intents and purposes, there is no real change since Brexit in relation to the application of this legislation.
That's really helpful, thank you. So before we move on to some of the specific questions that people are posting and that we've done a bit of research on, we're wondering what the position is for new union reps. If someone is newly appointed or elected in their workplace, what do they need to take account of from a data protection perspective in order to carry out their role effectively?
Quite a lot, in fact. So I will try and give headline guidance.
Yeah, let's do that.
I think the first thing, which is often forgotten, which is important to emphasize, is if you are a trade union rep handling personal casework, remember that you may yourself be the subject of a data subject access request by a member. And therefore, I would suggest one important thing to bear in mind is to be careful in what you say and what you commit to writing. That's often forgotten. The starting point, though, I think, is to look at the resources that your own union has, which will no doubt include their own privacy notice. And I anticipate most unions will have their own support and guidance available. And if there's any issue about that, then you should find out and contact your union's data protection officer or their office, so that hopefully they could guide you to the information that's available. Because there are some broad issues which you need to bear in mind, I think, at the outset to understand, which is to understand the justification for what data of members you will be holding and why you'll be holding it, for how long you'll be holding it, importantly, how you're going to keep it secure, and where you're going to be holding it, and something I'll touch on later, I think. Take up any training that's made available to you from your union, which will be very specific about the practicalities of managing data in this context. The data protection legislation is not voluminous, but is quite a lot of it. What I would suggest, though, is you get familiar with the data protection principles, which identify how you should handle data and maintain it as accurate, and how it should be handled fairly, etc. Get to grips with those sorts of things as broad principles. And then I think, as I say, the main issue is to think through how you would expect your own data to be handled by a third party, and apply common sense principles accordingly. So in the main, you would not want your data to be passed on to a third party unless with your consent. And I think you start off with that assumption in terms of handling information from your member who you're acting for, you're representing. And you'd also expect that data to be kept secure. And so you take appropriate steps to ensure that you don't leave your computer open when others are in the room, and practical steps like that. So as a starting point, I think that that's the sort of guidance I'd give.
That's excellent, Edward. Thank you. And as we said, we will come on to some of the more specifics of this as we progress through the webinar. Okay, we've had a couple of questions posted about a similar theme, really. And I think lots of people are keen for an answer to this. So can you explain a bit, please? But some employers used to give reps information about new joiners to an organisation, but these employers are now saying that they can't due to the data protection regulations. Is this correct? And perhaps not just where there are new joiners, but up-to-date information on already existing staff. Is this something that, and can employers say that they can't pass this information on anymore?
The short answer is that GDPR can be used as an excuse for doing something which they could do if they wanted to. But I think I have to just say a few words about what the legal framework is, because the information which is held by the employer. To that extent, they are what are known as the data controller. And they have obligations in relation to the privacy of their staff, their workers. But that's not the end of it, because clearly a trade union will have a relationship if they're recognised with that employer, and the recognition agreement may, in some instances, regulate the way in which information is passed by the employer to the trade union regarding new joiners, or indeed updating staff lists, etc. And the agreement itself would evidence what would be described as a legitimate interest on the part of the trade union to have that information. Now, the way in which this works is that in order for the information to be passed across by the employer to the trade union, they have to satisfy themselves, the employer has to satisfy itself, that one of the conditions for processing is satisfied. And there are conditions which are satisfied where the legitimate interests on the part of the trade unions receive that information. But it will be subject to there being appropriate safeguards regarding protection of the rights of individuals. Now, what employers often do is say, well, it's just too difficult. And that tends to be an approach which I don't think it is a good reason, but unfortunately it can be used that way. So what I would suggest is this. First of all, I think in terms of any agreements that you have, collective agreements for recognition you have with employers, so far as possible, and I appreciate, well, maybe counselling perfection, but at times one has to aim there and hopefully secure sufficient, is to have agreements which address the scope of the information that will be passed or intended to be passed by the employer to you, how long you'll keep it, and what you'll do with it, what steps you'll take in terms of making it secure, and provide effectively comfort to the employer that the information they provide to you will be dealt with appropriately. And then there is scope to undertake what is known as a data protection impact assessment, which can be used effectively by the union. And I think you need guidance from your own data protection officer or union in completing this. But there are forms online at the Information Commissioner, which will identify the steps you can take or consider to put in place to provide comfort for the employer that you'll be handling that information with due regard to the rights of those people whose information will be passed. Now, the employer will also have had to be open with their new starters as to the fact that information is going across to the trade union. That doesn't need to be with their consent, by the way, but it should frankly be included in their own privacy notice. And if they are recognised, if the union is recognised, one would anticipate that that would happen. So it's a long answer to a short question. The short answer is that I fear GDPR is used incorrectly by employers as an excuse when there is a way round, but it does require their cooperation, because there's no obligation to provide that information, but certainly GDPR is not the reason for them not to do so. And particularly where you have a recognition agreement, it seems to me that there is a greater scope for you to be able to secure arrangements for that information to be passed over to you.
That's really helpful, Edward. Thank you. And I'm just monitoring a couple of the comments that are coming in on the chat. If you have joined late, don't worry, we are recording this, so you will be able to watch a recording of the session afterwards. And my colleagues and other viewers are posting helpful links in the chat panel that provide further information on the things that Edward's talking about. We will also send a list of those round to everyone registered. Okay, so my next question is something you've already referred to briefly. What's good practice for workplace reps when they're storing trade union related personal data? What are sort of some really practical things they should be doing?
Well, ideally, that information will be stored or managed on the trade union case management system or trade union systems. And some unions I know have greater capacity than others in terms of their own systems, largely because of the numbers. Others have to rely on reps using either employer systems or their own home computers, and there are different considerations for each. But broadly speaking, you need to ensure that, particularly if you're working on the work system or even on your home system, so far as possible, you keep your data regarding your personal casework on behalf of members under in a secure password protected area. And importantly also that your laptop at times may have to be kept under lock and key. I mean, it really is depending to some extent what your own personal circumstances might be regarding who might have access. You need to ensure, so far as possible, that there are appropriate backup in place so you don't lose the data. Then you move on to how do you communicate? Some information which is communicated can be very highly confidential. You might well, from time to time, have information on the medical condition of your member, medical reports, whatever. My advice would be, so far as possible, try and encrypt that information, so password protect as much as you can. I think
Okay, it looks like we might have just lost Edward for a second. I'm going to try and just bring him back. Just please bear with us, everybody. We've just lost him for a second. There's a little wobble in the internet connection, but I'm bringing him back on screen now. Thank you for your patience. These things happen at times. He'll be with us shortly. Hopefully you can all see and hear me still. Great, thanks for replying, Paul. You can see and hear me. I'm just trying to bring Edward back. Okay, it's not working at the moment. Right, I will keep trying. In the meantime, if you've not voted in our polls, please do so. They're at the bottom of the screen. We've got a couple of questions for you because we're really keen to hear what about our reps and how you're accessing our webinars. There's so many of you on today. We think it's a great opportunity for us to find out more about you. Oh, this isn't working. Edward, if you're there, can you just try refreshing your screen? I mean, it's telling me that you're still online. Just try refreshing your screen and we'll try again. Okay, Edward, I'm hoping that you can hear me, but if you're not, it looks like you're probably just trying to re-log in at the moment. Yeah, Edward, if you're there, can you try leaving the webinar and coming back? I'll stay here the whole time because I need to stay on. I need to stay online, otherwise we can't restart it. But if you leave and then come back again, I will send you a another invite. There's lots of jokes from our audience about how you could come back as a cat, like the American lawyer who appeared with a cat face. But any way you want to come back to us, we'll be really grateful. Ah, looks like you're connecting now. Excellent. Hey. Hi, welcome back. We lost you just for a couple of minutes, and don't know whether you could hear us, but
Everything.
Okay, you're back. No worries, which is fantastic. So we were talking about the good practice for storing trade union related personal data, and you'd started to tell us about some of the practical tips for reps. So when you're ready, the rest of the information on that would be really helpful.
Yes, I think just to recap, I talked about security and how you deal with that. I think there are other issues which need to be addressed, which go to retention, which will be to comply with your union policy and, as I say, keep material for as limited period as is necessary. And preferably, if a case is concluded, if you can pass it to the union to store rather than for you to store, so much the better if it's on your private home systems. And then the other issue in terms of security, in terms of keeping that sort of data and how you use it, is ideally you secure the consent of your member before you pass it to any third party, and that might include the employer. There will be some implicit consents that they effectively are giving for you to run their case. But when it comes to highly sensitive material, for instance, if you get a medical report or the like, then you should, in my view, get express consent from the member to pass that on to the employer.
Thanks, Edward. That's some really helpful practical tips there. And you've touched already on the fact that many of us are currently working from home, and that we've had a question that relates to this. So I'm working from home, you are, many others are. A lot of reps work is also being done from home online. So what kind of storage equipment should reps be requesting from their organisations or their unions to fulfil this regulation about adequate safe storage?
Well, I'd say ideally, you would be working from home on a system provided by your union. That is the ideal, and that may not be the case for some years to come in some instances because it's extremely difficult to establish it. But that is the ideal because it means that ultimately you're dialing in, you're logging in to their system rather than your own. The real difficulty comes when you're maintaining the information on your own system, which, so far as possible, I've dealt with already. When it comes to what IT equipment you might want, I have to say that I'm not the person to answer that question because I'm not savvy enough in terms of IT equipment. That's not my thing. So I think that but Nevertheless, if you are working at home, there's still health and safety obligations imposed on your employer to ensure that you've got appropriate equipment and seating, etc., which need to be complied with. So I think that's all I can really say on that.
Thanks. That's helpful. I'm sure on a union by union basis, these issues will be different. So we've talked so far about quite general principles around GDPR, but we've had a question about a specific case. So can you talk a little bit about, please, the EAT decision in UCL, so University College London, and Brown, and what the implications of that are for reps, please?
Yes, I think I should caveat what I say by indicating that this was very fact specific, and that UCL in the case in question didn't, or the issues surrounding data protection at least, were not fully canvassed at the employment tribunal. And that in another case, there may well be more information that would emerge, which may have given rise to a different decision. But I think, nevertheless, as it is only a first instance decision, the employment tribunal, I'll come on to the EAT in a minute, it'd be wrong to assume that every other case will follow the same pattern. But what happened in this case was there had been a long-standing practice where the union in question, UCU, had used the employer email system to communicate to not only its members, but to all staff, effectively non-members as well, on matters of relating to union activity. And then after some years, I think it was 14 years or so, that practice had been ongoing, the employer decided that they would take a different approach to all staff emails. And they took the view that, rightly or wrongly, that all staff emails could only be generated by senior managers, to stop, in effect, the reasoning given was to stop unwanted volumes of email traffic, and that the alternative would be, however, to have opt-in arrangements where people could opt in to receive certain types of communication. The representative of UCU, Mr. Brown, effectively collated his own list, which effectively replicated the full company list pretty close to, and was using that to continue effectively practice that had occurred before. And he was disciplined for that, having been told that he should stop it, and he didn't. What the employment tribunal found was that when he was both preparing that list and when he was using that list, he was undertaking trade union activities, and as such, the disciplining of him was a breach of Section 146 of the of TALCRA, in that it had been taken with a view to deterring him from undertaking trade union activities. Now, the Employment Appeal Tribunal, to whom the employer appealed, dismissed the appeal, in my view, fairly perfunctorily, in terms that they determined that there was sufficient for the Employment Tribunal to reach that conclusion. What UCL were seeking to do was to suggest that the activity of Mr. Brown in collating that list was itself a breach of the data protection legislation, even suggesting at one stage that it might be give rise to a civil or criminal offence. And the tribunal, this was raised very much at the last minute before the Employment Tribunal, although it was canvassed in the Employment Appeal Tribunal, they took the view that there was sufficient for the Employment Tribunal to find there was no such issue, and therefore it was appropriate in those circumstances for the Employment Tribunal to reach the conclusion that they did. Now, I think that the important point is the first one, that it was very fact specific. So it is not a license to act in any other employment scenario as Mr. Brown did. The evidence given clearly persuaded the tribunal, or rather the employers did not persuade the tribunal, that they were doing this for any other reason than to hinder trade union activities. There may be other circumstances where they might yet be able to, other employers might be able to take a different line. So I would be nervous about raising too many general lessons from that case.
That's really helpful. Thank you, Edward. And I suppose it's worth bearing in mind that this is still a reasonably new piece of legislation, isn't it? So the things might develop as time goes on and as more cases are brought before tribunals and the courts. Okay, so we've had a whole batch of questions really about a key task of workplace reps, and that's mapping. So all union reps are encouraged to map their workplaces to find out about membership, about collective issues, health and safety, etc., etc. So how does data protection legislation affect mapping members and crucially non-members in a workplace or in a series of workplaces? So perhaps you can say a little bit about that, please.
By all means, I think that this again goes back actually to similar principles that I was discussing earlier in relation to the information about new starters and the like. The difference with mapping, as I understand it, however, is that once the information is obtained about individuals within the employer by the union, they will then distinguish between those who are already members and those who are non-members, if I'm right. Is that correct?
I suspect it varies by union and by individual workplace. We sort of the traditional mapping information can be gathered in a whole range of ways. It could be as practical as the rep going into each department and actually talking to people, but they may well base that on lists of membership information that they've got from their union. I think it varies, but people are saying in the chat as well that yes, that's correct, but I suspect there are some variations also.
Well, I think that the starting point here is that when it comes to information about your own members, then the conditions for processing that data is permissible within the trade union for trade union legitimate interests. Whether you are, if the fact of trade union membership is what is known as special category data. It's data which the GDPR and indeed earlier data legislation has identified as being suitable for more protections than other data. And that means that you've got to be particularly careful about how you release information regarding somebody's membership. But it is understood, and the legislation recognizes that unions have to function, and where they have data regarding their own membership, then provided the processing is in pursuance of their own legitimate interests, then within the union, they can process that data. And for this instance, it seems to me it's a legitimate interest for the trade union to recruit and organise, and therefore for reps to have available lists of members within their own workplace from their union, using for that purpose only, or for that purpose, and maybe other legitimate interests as well, allows them to map to that extent. When it comes, however, to the issue of non-members, you are then processing information about individuals by reference to their lack of trade union membership. So that's special category data. And of course, they're not a member. So one has to look for alternative justification for effectively processing special category data. And there is a further provision in the GDPR which will potentially permit that processing, where it's necessary, I'm sorry I have to read this, necessary for the purposes of carrying out the obligations and exercising specific rights of the controller, so far as is authorised by collective agreement, provided that is a collective agreement pursuant to UK law, in other words, made between the trade union and the employer. So if your recognition agreement regulates this information, or the processing this information, if the employer has at the same time notified through their privacy notice that the information is going to be provided to the union, and if the union itself has a privacy notice which identifies how they're going to use this information about non-members, then it seems to me there is a route through to allow a so-called mapping, which is, not the most straightforward, but nevertheless, I think it is there for unions to progress. Unfortunately, some of these difficulties may be such that employers are problematical. We've identified that already. And it means that in the larger workplaces, you're going to be highly dependent on having the individual reps getting to know the position on the ground for the purposes of recruitment and organisation, rather than using, I'm afraid, technical uses, making the best use of technology.
A question that's just arisen, listening to your latest answer. If a union is recognised in a workplace, would you recommend having all these eventualities kind of covered in the recognition agreement around data sharing? Is that advisable, or do you know of situations where it's already happening?
I do know some situations where it's happening. I think to a large extent it depends on your relationship with the employer. There are some delicate questions around how data is shared, and delicate questions about the use of employers' IT systems for trade union business, because that can give rise to some quite knotty problems regarding data subject access requests and the like. Particularly if the system at work is being used for trade union activities, then having a recognition agreement which regulates, sort of puts in place protections and firewalls or whatever, I think that would be a sensible way forward.
Okay, that's I think an important thing to bear in mind. Okay, next question. Does GDPR make any difference to the provision of information to unions by an employer under the ACAS Code of Practice compared to maybe the Data Protection Act? Has anything changed?
Are we talking there about, so I'm not quite certain what circumstances we're talking about information being provided. Is that for collective bargaining purposes? I'm not sure.
The question doesn't specify, but let's say it is for collective bargaining, so that we can answer the question.
I'd understood from discussions prior to this session that there might be some concerns about data sharing or statistics being shared regarding the breakdown of workforce by reference to age, sex, and the like, to identify whether there are equality issues in relation to pay structures or other underlying problems with any pay structure. Now, it seems to me that should not be impacted by GDPR because the information should be anonymized. And you will not be able to identify an individual by reference to the information that's provided. Of course, that doesn't apply if you've got one or two people in a particular workplace and that's it. But in the main, it won't identify any one individual. And to that extent, the provision of statistical information, as I see it, is not precluded by GDPR.
Excellent. That's really helpful. Thank you. And I think the person who asked the question said that's exactly what they meant. So great stuff. Okay, we've got a question which I think gets to the heart of the unusual nature of unions and the way they operate. So the asker has said, in addition to the formal membership system used by unions, for example, in Unison, they have something called WARMS. WARMS. What data on branch members can the local branches hold? Is this different from the national system? Can they keep local lists for ease of access for regular comms?
Well, I think this is one of the issues about having lists of members is that it is to ensure that, first of all, it's secure, and to ensure what the purpose of keeping that is proportionate. One thing that you can't do as a rep is, having got your list of members, then use that for any campaign you may have personally regarding re-election or election to executive committee of the organisation in question, because that information has not been provided to you for that purpose, and that's very important. When it comes to why you need the list, then if it can't be managed centrally by your union, then on the face of it, in other words, communications aren't managed centrally and you have to undertake the communications yourself, then with appropriate protections, it seems to me that can be provided to you for that purpose. But you will be probably, the union central office may well want to constrain your use of it very specifically, so as to avoid any issues which might arise from a data breach. Because, of course, if you were inadvertently to copy that list to a third party, even to the employer, then it's the union who would be held accountable potentially under data protection legislation. And to that extent, there will be some nervousness about the scope of which, or the extent to which that information will be held by you. But needs must at times, in order to organise and to function as a union rep and a branch officer or regional officer, you may well need to have a means of communicating, will need a means of communicating and knowing who your members are. And if it isn't managed centrally, it can't be managed centrally, then I can see that with appropriate restrictions, appropriate protections, that information could be provided to you.
Yeah, that's really helpful, and I think a couple of viewers have commented similarly in the chat that. For example, Unison encourages the use of the WARMS and never a local list, and somebody else, it's disappeared now, but somebody else said you should request a updated list regularly because membership changes, people change their consent, so to always make sure you're complying, best to speak to the central data control for your union.
Yeah.
Okay, I'll just see if we can answer just maybe one or two more questions. We've had a question about providing comparative pay information in equal pay claims, given GDPR. In the case for workplace grievances and for cases at a tribunal, is there an obligation for a company to provide this information?
Well, when it comes to a tribunal, they may be required to, because first of all, there will be an exclusion when you're protecting legal interests. So that, and indeed, it could be ordered by the tribunal to provide the information. When it comes to sort of levels of grievance process, where that becomes a live issue, then again, I think there are exceptions under the GDPR requirements for confidentiality, etc., where the information is required for the purposes of legal claims and progressing of them and defending of them. To say that you can force the employer to provide that information, well, you can't. You can only force them to provide that information if you go to a tribunal. Unfortunately, you get an order of them to do so. But I don't think GDPR precludes them.
Thanks for that. We've had an interesting question, really, about freedom of information requests.
Yeah.
And the questioner seems to get a lot of requests forwarded to them by the employer in response to these. And do you think it's worth having some sort of template guidance on explaining that unions are not subject to FOIs when it's a request that's been made to the employer? They're thinking, for example, of joint payroll and HR functions. And if this is the case, perhaps do you think a template would be useful that all unions could use in this situation?
I think it would be useful. I think it would be, in the first instance, it would be helpful to know a little bit more about the circumstances in which these requests are made by employers, because I think the position is relatively straightforward that the Freedom of Information Act does not apply to a trade union, even if they have a predominance of their members in the public sector. It doesn't seem to me that it applies. There may be some misunderstanding about the Freedom of Information Act, created in part because, unusually and exceptionally, as I understand it, the Police Federation are subject to Freedom of Information Act. But that was a particular issue that was dealt with at the time of the review into their structures from following Plebgate. They are subject, but I don't believe there's any, I've not heard of any intention that other unions should be.
Okay, I mean, if we, at the idea of a template, the questioner has even suggested that maybe it could be a TUC approved template. I can't make any promises, but colleagues who are on the webinar, maybe it's something we can come back to or even consider. There's been a question as well about anonymous surveys, and this particular one is about gauging staff stress levels related to the pandemic. But let's imagine it's any anonymous survey. There's a suggestion that this survey needs to go through the employer's ethical approval before distributing it. If it's anonymous, surely there's nothing, there's no consideration around GDPR. So is this correct? Is the employer correct here in saying it needs to be approved?
Well, the employer might be maybe saying that they want it to be approved because it's being used, it's been circulated on their own systems, and they may be relying on their own IT policies rather than actually GDPR. I don't think GDPR requires it, no.
Okay, well that's always helpful, I think, to consider the systems that are being used to hold the data. Final question, because we are running out of time. Something that's very topical. Is it lawful under GDPR for an employer to withhold instances of COVID infections if requested by safety reps, or to give details of the location of these particular staff, especially if perhaps there's this could be the infections occurred at work?
Right.
Is it too big a question at this point?
I think it's quite a big question, that.
Okay.
I mean, I think there are a number of conflicting considerations on that. One of them, obviously, there are different interests there. There's the privacy of the individual who may be infected, as well as the health and safety considerations of those who may end up working in their vicinity. And I think that where an employer will have particular duties to other staff, if they become aware of somebody who is COVID infected, then the obligation on the employer should be to have the welfare of not only that individual, but more specifically those who aren't infected in mind, and take appropriate steps. When it comes to providing information about that, I'm going to say it's a bit more complicated than for me to answer on the hoof, I'm afraid.
No, absolutely. I appreciate it is a complicated question, and we've had lots of webinars about the specific role of safety reps around COVID. So perhaps it's something that we'll come back to on one of those. We have sped through very nearly an hour, and we've covered a huge amount. So thank you so much, Edward, for answering so many questions. We've got through quite a few. This is a huge subject, so we're very aware that there's lots to cover, and we really appreciate all the information that you've given us today. Before we go, just a quick reminder to everybody to vote in the polls if they've not done so. They're just at the bottom of the screen. We thank you all for joining, and just a quick plug of a TUC event that is coming up in the first week of March. So the TUC has a big campaign at the moment for a rally for a workers' budget, and we can't have a real life rally at the moment for obvious reasons. So we're having a virtual rally. You can register to join this, and my colleagues will post the link to register for that in the chat shortly. So please do take a look, sign up, and join us online for that session on March the 2nd. So that's thank you from me for joining us for today. Thanks to Edward, and thank you all for being a great audience and for bearing with our little technical hitches. So we'll see you again soon, and yeah, continue to enjoy GDPR. Bye bye.
Cheerio.